Any mention?
May I plead your lordship? I beg to mention item number 10. I'm appearing on behalf of Madam Sering Yangi. She is on sanction leave. Can you take up the matter after 2 weeks?
My lord, this matter has been heard earlier, Lordship.
Oh,
Have been reserved for judgment also, Your Lordship.
yes, sir. This is for the parties to refresh the.
Yes, Lordship.
When is he coming?
Next week she's joining you. She's on leave till today. She's on leave. Can you take up the matter after 2 weeks, your lordship?
1 week. What matter? 1 week.
Hello.
My lord, I beg to mention item 20, yes. 20, item number 20.
Three weeks.
2 weeks. Oblige.
Please, Your Lordship, I beg to mention item number 18. I'm praying for 2 weeks' time, Your Lordship. As conducting counsel, Mr. P. Nongri is out of station.
Two weeks.
Highly obliged, Your Lordship.
Your Lordship, I beg to mention item number 14. The conducting counsel, Mrs. Yangi, is on leave, Your Lordship.
2 weeks.
Obliged, Your Lordship.
May it please your lordship, I beg to mention item number 21. The matter may come up after 3 weeks, your lordship. Item number 21.
3 weeks.
Highly obliged, your lordship.
Your lordship, I beg to mention item number 9, your lordship. I'm praying for 2 weeks' time, your lordship. Conducting counsel is having some personal difficulty, your lordship.
All matter.
Yes, your lordship, this is 2022 matter.
It's having some personal difficulty today, your lordship. Short date may be given, your lordship.
In this matter, my lord, earlier we were representing for the CM, my lord, and subsequently what happened was that the CM was removed and an acting CM came. So at one point of time, then we did not represent anymore, but now the CM has been restored, my lord, so we will be representing again, my lord. We have an instruction to represent him once again, my lord. Respondent number 3.
No, but then in the meantime, have you?
No, the course title has not been changed. That's what I come to my decision.
Your power has not been released.
No, my power has not been released, my lord. But in the meantime, what happened was because they have removed him, and then acting CM was appointed. So we have no authority from the acting CM. So, but now since he has come back as full-fledged CM, yes. So we'll be our appearance may be recorded, my lord. We have.
I'm for respondent number 6. I'm for 1 and 2, your lordship.
How long?
2 weeks, your lordship.
Be sure next time no more.
Yes, sir.
These all matters, we cannot just go on like this. 2 weeks.
Highly obliged. Yeah, please, your lordship. I beg to mention item number 16 and 17, my lord. It is a connected matter.
Two weeks.
My lord, item number 3 also, my lord.
Item number 3.
Yes, my lord.
Very old matter. I have made it clear that no further adjournment in this case.
Yes, my lord, but then the conducting counsel is on disposed, my lord.
Who is the conducting counsel?
HR not, my lord.
Next time, no more adjournment.
Yes, my lord.
1 week.
May it please your lordship, item number 22, your lordship. Beg to mention item number 22. Lordship, item number 22.
Lordship, I pray for 2 weeks' time, Your Lordship.
3 weeks.
May it please Your Lordship, I beg to mention item number 11. Your Lordship, I pray for 2 weeks' time since the conducting counsel is on sanctioned leave.
2 weeks.
Your Lordship, I beg to mention item number 19. Mrs. N.G. Sheila has some personal difficulty today, Your Lordship.
My lord, I am the appellant here.
2 weeks.
My lord, a small mention, my lord. The appellant here has already completed 75% of his sentence, my lord. A suspension of sentence.
Have you filed a separate application?
Not a separate application. In the main application we have mentioned, my lord.
I think you should have filed a separate application.
My lord, I should have been, my lord, but
You don't confuse that with the main appeal.
But the prayer was made,
Because
my
the appeal
lord.
will be heard on merits.
Merits, my lord.
This is a separate.
Separate miscellaneous application should have been filed, my lord.
Okay, we'll list the matter after 2 weeks. In the meantime, you file a separate application.
For suspension of sentence. Very well. My lord, 2 weeks time because I have to send it for the signature of the his serving, my lord.
Where is he incarcerated?
Last he was in a district prison here, my lord.
No.
But Shillong, my lord. But I heard that I'm not sure, my lord, that he has been shifted, my lord, to another prison. That I have to find out, my lord. So if he is shifted, my lord, then it'll take a lot of time.
See, you do one thing. You find out and you coordinate with the secretary of the DLSE,
My lord.
and they will do the needful.
Very well.
If signatures is to be to be got from him, or to be the jail authorities to be approached, they will do it.
Very well, my lord. I'll do it.
2 weeks then,
2 weeks, my lord.
or 3 weeks? It's up to you.
Let it come after 3 weeks, my lord. I will be on the safer side.
3 weeks.
Obliged, Your
Deeply
Lordship.
obliged, my lord.
Supplementary list, item number 1.
Please, Your Lordship, the paper book has been filed.
This letter counsel for the appellant has submitted that the paper book has been filed. Accordingly, as prayed for, this is matter for hearing after 3 weeks.
Obliged.
Item number 2. My lord, this matter, my lord, the hearing is concluded, my lord. This matter, hearing is concluded, my lord. This is
What is, you're supposed, parties are supposed to file the written argument.
my lord, we have already filed our written argument, my lord. We are supposed to file bullet points, my lord. So we are praying, we are filing in course of the day, my lord. This matter may be reserved for judgment, my lord. We are filing it in course of the day, my lord, today.
Otherwise, it's, oh, I'll fix this on. You
My
file
lord, may keep it for CAB, my lord.
Fix it on Monday. You file it before Monday or
My lord,
Tuesday,
my lord.
but you file it by
My lord,
Monday.
we'll file it today itself, my lord.
You can file. Miss Leonard, counsel for the petitioner has submitted that the written argument on behalf of the petitioner is ready and may be allowed to be filed in course of the day. Accordingly, as prayed for, this matter on Monday.
Hello, Your Lordship.
Item number 4.
This matter was heard.
My lord, this is that regarding that OBC certificate, my lord.
No. Okay. So this was I mean this is also part of matter.
No, my lord, this has to be heard, my lord. This has to be, this is heard.
Please, Your Lordship, the learned senior counsel, Dr. N. Muzika, is unavailable.
My lord, if I'm pray, my lord, it may be fixed on Monday, my lord. There is some urgency, my lord, this matter. It's a legal aid matter, my lord. My lord. Let it come up on Monday, my lord.
Monday may not be possible. Monday we have a number of division bench sitting.
Tuesday, my lord.
Tuesday, yes or no?
Tuesday is what date? 18?
18. Sun.
Ano? Sun. What total na tangga hearing? As prayed for by the parties, this is matter on Tuesday.
Oblige, Your Lordship.
Item number 5.
Whether the petitioner have finished or not?
Yes. Who's here?
Your Lordship, learned senior counsel is not available right now, Your Lordship.
My lord, this matter, I have a serious objection, my lord. My lord, can you look? The order sheet has become thicker than the writ petition itself, my lord. Since 2022, my salary has been stuck, my lord. So this matter, my lord. So if they are not interested, let it be dismissed,
Lordship,
my lord.
in item 8, my friend, I think is in item 8. He can do.
Item 6.
Oh,
5,
item?
6, 5, 6, 7, 8. These are all connected
Yeah,
matters.
connected.
Yes, my lord. So
5, 6, 7, 8.
yes, this has to be heard all together, my lord.
8 is salary, Your Lordship. It can be.
7, item number 7, Lordship, there because they have challenged that she is the counsel for the petitioner item number 7. They have challenged the constitution of an interim managing committee, Lordship. Now, Lordship, there is a new managing committee, Lordship. So, in view of the order for constitution of a new managing committee, the writ petition is in fact. I will place that order on the next date, Lordship.
In that case, my lord, I have to seek instruction from
That-
the petitioner.
So I'll place that order next date, Lordship. In the meantime, she can.
Because in this limbo, my lord, we the teachers who got selected are the most sufferers, my lord. Managing committee has nothing to do. It's only the ego fight between them that the teachers are suffering. And since 2022, we have been teaching the school. It's because of us that the managing committee, whether at interim or whoever, are there. It's because of the teachers, my lord. Now the teachers are made to suffer.
You are still teaching.
I'm still teaching, my lord, because my lord, they are.
You are not getting your salary.
We are not getting our salary. Simply saying that now in my item number.
There is no stay to the.
No, there is no stay. There is no stay. We have been teaching. Now the government has taken a very categorical stand in my petition. They're saying that the managing committee is not giving the statements. What can I do? I'm ready to release. This is what the government is saying.
I'm not in that matter. So please don't point out.
Who was there? Mr. Kharmi was there. She was there. She's there. Is there affidavit? Swapnil's affidavit. It's clearly saying that they are not sending this because my.
But the fund comes from the government.
Funds comes from the government. Government is saying that you submit the statement, then I'm going to release the money. So the managing committee, the ego clash.
Now he says managing committee has changed now.
He is saying, so whoever may be the managing committee, my lord, it's only the ego clash, nothing else, my lord. It's just the ego clash, my lord.
But,
so what happened here?
See, if there is no stay to your appointment.
Appointment, yes, my lord.
Then you should have. You are teaching. You should have got
Yes,
this.
and Justice, thank you, my lord, in his order very clearly says that if they are entitled to, please pay them.
Yes.
Justice, thank you very clearly said.
Why didn't you come for contempt?
My lord, I did not come for. This is exactly, my lord. It's luck for them that because now whom I file contempt, they keep on changing 2 days managing committee. Every 2 days there is a new managing committee comes up, my lord. But the thing is that, my lord, the teachers are teaching, so they should not be allowed to suffer in this way. 5 teachers are there, my lord. Now who are challenging also? These people who are challenging our appointment, they sat for the interview. They saw who are the interview members. When they found themselves not selected, they come forward and saying that there is a biasness. Can that legally that can be challenged? Once you open with your open eyes, you come and challenge. You don't even have a locus. That is the reason why they have been stretching. That's I've said just in a lighter word, my lord. My lord's order sheets have become thicker than the writ petition. so for that reason. So my lord, this my lord, I don't know all if. It seems that I'm the only one who is ready. Nobody else is ready. What can I do?
It also speaks volumes about the conduct of the court. Being too lenient.
My lord, I'm not casting anything on my lords. Because what can my lord do also when the parties are not ready to put up their case, my lord?
You see, it's like that, like the saying is, you can take the horse to the water, but you
can't make it drink. Exactly, my lord.
No, but seriously, I think,
my lord, yes,
these old matters cannot be left.
2022 matters.
It has to be heard, your lord.
It has to be heard.
The managing committee will have to defend their action. The person on the old managing committee they'll have to defend their action, your lordship.
Okay, we'll hear the matter.
No adjournment, my lord. Maybe fix a date, my lord, but no adjournment, my lord.
Then 27, your lordship.
On a slightly free day, we'll take up.
Yes, my lord. Then Thursday, my lord, 20 and 21 we can.
Wait.
21.
21. Hadirin tu Arkusang, MD Arsan.
Well, it's 24th, that last week, my lord.
25th.
25th will be little problem, my lord. I have my personal PIL, my lord, in the Itanagar bench, where I am the party.
Then 27.
27, I'll be. My lord, then let's take it on 1st of September, my lord. 1st of September. Tuesday, or any 1st September, then it goes like that.
Okay, but no more adjournment.
No more adjournment.
No more adjournment?
Yes, my lord.
If adjournment is sought for, heavy cost will be.
Heavy cost, my lord. It applies to us also.
To be paid to me. Judge is giving, court is giving cause only to others. Why not to themselves?
So when it's coming?
My lord, which one?
Accommodation has been sought for on behalf of the petitioner. However, the prayer has been strongly objected to by Mr. Piovin, the counsel for the respondent. I have to case in
WPC number.
also I bracket into I have to on the ground that matter has been pending for a long time, and in the meantime the respondent, who is only one, you are only one teacher.
No, my lord.
No, you are
There are actually 5 teachers.
no, but
Different
in your
teachers.
case,
In my case, I'm for it. My lord,
only
this
one
is-
teacher.
Yes, only one teacher, my lord. Respondent number 8.
Paying for respondent number 8. Kunu to? Respondent number 8. Who is present? Respondent number 8. Who is the teacher of the school and is still teaching there? has not received her or he his
Her salary.
her salary all along. Hence urgency. This court has considered the submission made, and on since prayer for adjournment has been made on grounds of personal difficulty, the prayer is allowed. However, it is made clear that no further adjournment would be allowed in this matter, and parties are directed to make adequate representation on the next date. Next, as agreed to by the parties, list this matter on 1st September.
My lord.
Apply, Your Lordship.
Passes all the other cases will same order.
Item number 12.
May it please your Lordship. Lordship, I appear on behalf of the petitioner.
Yes.
Lordship, this is a land acquisition matter in which, after a long list of facts, your Lordship, the petitioner had disputed the title of the beneficiary of the acquisition compensation. And the petitioner was espousing the interest of the Khoon Ki Hajar of the CM ship. And while this title was still under...
You filed a writ petition.
Yes, my lord.
Yes, your Lordship.
Then how are you affected personally?
Your Lordship, I am not affected personally
Then
per se, your
then
Lordship.
you should have filed a PIL then.
I bow down, your Lordship. The only point in this regard I would like to bring to your Lordship's notice is that in respondent number 3, which is the CM ship, your Lordship, the respondent has submitted on sworn affidavit that the petitioners should be enabled to espouse this cause on behalf of the Khoon Ki Hajar.
Who is respondent 3 to give you that license?
Your Lordship, the CM of the CM ship, your Lordship.
Yes.
The Darbar itself.
He will have his own cause. He will have his own stand.
I bow down, your Lordship. That is the only source of my representative capacity.
Anyway, as far as maintainability is concerned, the matter will be heard, no doubt.
Yes, your Lordship. Your Lordship, I used to be the CM of the concerned Darbar, and by virtue of that, I am the only, the petitioners are the only persons who are well versed with the facts relating to this cause of action.
But is there any proof that you have approached any competent authority? You have made any complaints or representation?
Yes, Your Lordship. Starting from 2012, Your Lordship, there was a petition filed in the Guwahati High Court, and in that the Honorable Court had noted the representative capacity of the petitioner, and at the same time they had also pointed out that the other remedies they had ultimately not deemed it fit to intervene in the writ jurisdiction, but they had left it open to the petitioners to espouse the cause through other means of law, through other modes permissible under law. And after that, Your Lordship, there has been a series of litigation in which the petitioners have been involved, which related to the title of the land sought to be acquired. And Your Lordship, the petitioners had highlighted to the acquiring authorities, which is respondent number 1, that the title is under dispute. And the respondent number 1 had also agreed that compensation will not be released. And this was until the pending litigation has been resolved. And this is something which was also noted in the acquisition certificate, which is annexed to the writ petition, Your Lordship. And despite this, and despite the petitioners repeatedly writing letters to the respondent number 1 authority about the pendency of the litigation between concerning the land, eventually the petitioner filed an FIR, I apologize, Your Lordship, filed an RTI, and therein the petitioners got to know that the compensation has in fact been released. And thereafter, Your Lordship, the petitioners approached.
See, now if in the meantime the compensation or rather the award has been released, then
yes, Your Lordship.
In that case, you have to amend your petition, or you have to seek other means to to cause recovery of the said amount. Then
yes, Your Lordship, my primary prayer is to direct the authority to retake the compensation which has been released.
Are you a claimant in any case?
No, Your Lordship. There's nothing on record to suggest that I am personally a claimant. My primary cause of action is in a representative capacity.
So we'll have to hear the matter then. When do we hear the matter?
Next week,
we'll take it up next week.
Your Lordship, I would also like to file a short affidavit to bring on record this inquiry report issued by the KHEDC. I'm for respondent number 3.
Oh, but what is the relevance here? What is the relevance here?
This is the inquiry report. Your Lordship, this is an inquiry case filed by the...
What is the relevance in this case as far as that report is concerned?
Your Lordship, this is the release of the alleged compensation and of the misuse of funds. So it's regarding the misuse of funds by me. So they've issued a report dated.
We are here with regard to a compensation of a particular area, madam. And we have said that the compensation was given after examining all the documents. And so therefore, madam, they are here. What my friend is submitting, what I could understand is that a subsequent instance where they have been alleged that particular that money has been misused. So madam, we are not on that issue. We are here on the issue of land compensation, which has been disputed, and who has received or by virtue of what capacity. So madam, we have given because we have found that this person, the person who has received, have furnished all the sufficient documents and we have given to them. And the writ petitioner has come 1 year after compensation has been given. There was never any litigation pending before the executive magistrate or before the trial court. Also, they have only come objecting the release of the compensation without substantiating any document of their ownership. So that is the case. So I believe my friend's affidavit may not be necessary right now, madam, because there's an allegation of misuse of that fund. So that we are not on that point. So let the matter be heard. If at all a situation comes, madam, that can be taken care of, madam. At this point of time, madam.
Yes, it's compounding the issue.
Yes, madam. We are here on the particular amount, madam, which have been released by the collector.
Because the issue of, again, like I said, I think the issue of maintainability has to be first sorted out.
Okay.
We'll take up this matter after 2 weeks. But be sure on the next date, the matter will be finally heard.
Yes, Your Lordship.
Yes, Your Lordship.
Pre-made by parties, this matter after 2 weeks.
Item number 13.
May it please, Your Lordship. Your Lordship, at the outset, we'd just like to bring this to the notice of this Honourable Court, that during the pendency of this matter was placed before the mediation committee, and in the mediation committee, Your Lordship, matter was referred in the month of February, and the deliberation it went on for almost 2 months. And in the discussion, Your Lordship, we have come down to only one issue left in this matter, and that is because I've been subscribing to GPF prior to the coming of the new defined pension scheme. And in this matter, the issue is that I've been given regularization prospectively. That is in the year of 2018, and I've been subscribing to GPF since 2009. So a clarity, because in the impugn order, Your Lordship, there is no clarity because I've joined my service in the year 2004, subscribed to GPF 2009, and now regularization 2018. So now the question remains, where do I fall when it comes to my service benefits, whether the old pension scheme or the new defined pension scheme? So in my humble and respectful submission, Your Lordship, since the matter with regard to pension, the department is not in a position, liberty to decide. It has to go to the personnel department. So in order from this Honourable Court to that effect, Your Lordship, because it's on record that I've been subscribing to GPF since 2009, and as per the law, as per the rule, Your Lordship, that only government servants are to subscribe to the GPF.
What is your government in that regard? Where is your government in that regard? As far as the GPF is concerned?
Para 13 of my writ petition, because initially when I came in before this Honourable Court, Your Lordship, through this writ petition, I was coming with the intention to pray for regularization retrospectively from the date of my joining. But then during the discussion realized that even with regard to settling this issue, that will suffice to me. That is, where do I fall when it comes to my service benefit, since I've been subscribing my GPF since 2009. So para 13, Your Lordship, is not very expressly provided, Your Lordship, but then it reads, Your Lordship, that the petitioner states that the Government of Meghalaya Personal and Administrative Reform B Department, White Office letter dated so-and-so, has clarified that the period spent by the government servant in continuous officiating capacity or an ad hoc basis shall be counted towards leave, increment and pension, etc. on the permanent absorption or regularization. So here, Your Lordship, the thing is that, Your Lordship, when I had first filed this writ petition, my intention, Your Lordship, as per my prayer as well, is to give me retrospective regularization. But the development that arise in the mediation, Your Lordship, we have come to a realization.
Have your services been regularized?
Yes, my service have been regularized by the order passed by this Honourable Court in the year 2018, Lordship. Because after serving for more than 14 years, 2004 I joined the service. After my service was not regularized, I came before the Honourable Court, and white order dated 10 September 2018. The Honourable Court have directed the respondent to regularize my service. The order is at page 11, annexure 2. So my service, no doubt, Your Lordship, and actually I've impugned
So
the...
you have no grievance as far as that is concerned.
Now, Your Lordship, my only contention is with regard to clarity, Your Lordship, that I pray that this Honourable Court may grant me that clarity as to where do I fall, because as per the rule...
It's for you to make your stand. It's not for this court to...
Yes, that is my case, Your Lordship. Now that my stand is that I'd like to also refer to one of the judgment passed by this Honourable Court by Justice H.S. Thank you, Your Lordship, in one of the matter very similar to my case, Your Lordship. The issue here is also, Your Lordship, very similar, where the petitioners, there are a cluster of writ petitions, Your Lordship, who have been clubbed together, where the writ petitioners have subscribed to the writ petition to the GPF, but then their pensions, Your Lordship, is unclear. So I'd like to take Your Lordship to para 4, Your Lordship. Para 4. May I read, Lordship?
Are we going to hearing now? I think time will not permit us.
Yes. Subject to convenience.
Earlier this matter up to 1 week.
1 week.
Mr. Karona, you be prepared?
Oh, my lord, I have a few objections, my lord.
Okay.
On the last day, my lord, I think I've given a judgment. So my only regard is whether this petition is maintainable on grounds of delay, laches, and acquiescence. Since the petitioner has already accepted the terms of regularization, can he come now after 5 years, more than 5 years, to
delay
for
laches?
Yes, my lord, to delay laches and acquiescence. Already accepted. Now after 5 years, during that time of regularization, he did not raise any objections with regards to the regularization. Now after 5 years, more than 5 years, he has come for I think so delay and laches, my lord. And
You are still in service?
Yes, I'm still in service.
Still service.
Now, as of today,
yes,
are you still subscribing to
Yes,
GPF,
I'm still.
or you are under
Currently, also I'm subscribing to the GPF. And with regard to
you are not
delay and
under the
laches,
NPS,
I have
not under the NPS.
not under the new defined pension scheme.
And my lord, so
it's just that with regard to the impugned order is not clear. At the end, if I retire later on, Your Lordship, because the regularization have been given to me.
Yes, my lord. So,
prospectively.
but then maintainability will be looked into. And my lord, so number 2 objection would be, can this court go beyond the pleadings and prayers made in his petition? Maybe the petitioner can withdraw his petition and file a new petition with regards to the new release. With regards to new reliefs, my lord, the prayers, correct. He is just praying for regularization with retrospective effect, my lord. There's no prayer with regards to the GPF and financial
If
constraints.
Your Lordship is satisfied with regard to the issue that I'm facing now, Your Lordship, there is no bar even in writ petition.
Mr. Jura, you have to be categorical.
Yes, Your Lordship.
As far as the pleadings is concerned.
Lordship, these are something that came up along the way.
If it comes, you see, you know very well. I don't have to tell you that.
Yes.
In course of proceedings, if circumstances have changed, you are at liberty to amend your petition. Have you done that? Amend your petition, amend your prayer.
Your Lordship, I'll satisfy to that, because Your Lordship, I don't think so. My petition is defective as of now. There are still something surviving for this Honourable Court to adjudicate.
My lord, here I am asking 50 rupees. Now if I say that 25 rupees will suffice, I am asking 50 rupees here. Now if I say that 25 rupees will suffice my prayer, that
Petition will not be defective.
Defective, Lordship. Here we said that yes, give retrospective regularization, and if the court finds that yes, only with regard to that part, then that prayer will suffice, Lordship.
But in any case, as far as regularization is concerned, you have no grievance now.
Now I think so.
Yes, it has been.
I have instruction, Your Lordship, that with regard to regularization, no issue. Initially, yes, but now Your Lordship has to keep things simple, because now it is a glaring difficulty even for the department, Your Lordship. Where do I fall? under the new scheme or on the old scheme?
The court can call upon the respondent
Yes.
to clarify.
Yes, yes, Your Lordship.
On premeditated parties, place this matter to 2 weeks.
Item number
Much
50.
obliged, Lordship.